Good evening. This is Making the Case. I'm Yodit Tewolde. We begin tonight in the city of Brunswick, Georgia, where the federal trial of the three men convicted of murdering Ahmaud Arbery entered day 2 of jury selection. Travis McMichael, his father Gregory McMichael, and their neighbor Roddie Bryan are charged with hate crimes and attempted kidnapping, among others, in connection to Ahmaud's murder. The federal trial begins just 1 month after the three men were sentenced to life in prison in a separate murder trial in a Georgia state court. With me now to discuss today's events in court is criminal defense attorney and former prosecutor Bernarda Villalona. Thank you so much for coming on. Good to have you on.
Thanks for having me, Yodit.
Bernarda, the presiding judge has signaled that she wants jury selection to be done by the end of the week. Now, if you remember, jury selection in the state trial took almost 2 weeks. We saw a similar request made by the judge presiding over the federal trial of the three former Minneapolis officers charged in connection with George Floyd's murder. He wanted jury selection done in 2 days, whereas Derek Chauvin's state trial took 2 weeks. I'm always concerned when judges are rushing the jury selection process. I think that they should let attorneys take the time that they need, of course within reason, for jury selection. It's an important part of the trial process, as you know, and the stakes are high. I mean, they're just too high. So should there be concern with the rate of speed that these judges expect to wrap jury selection, or is this how federal trials work in general?
So, Yodit, as you know, trials are won and lost in jury selection. That's why it is so important to take jury selection so seriously and take your time with jury selection. Because in the end, when you're presenting your evidence and your arguments, you're presenting it to the jury, who's going to be the fact finder in this case. So I am a bit disappointed, and I do get disappointed when judges want to rush through jury selection because of the importance of jury selection. We know, I believe, that about 1,000 questionnaires went out to the potential jurors in Georgia to get a federal jury. It seems that they may be close to narrowing the number. I believe they're trying to get either 36, I think that's the key number to get, and when you take into account all the strikes that the defense has and the prosecution has, so they can get to a jury of 12 plus 4 alternates.
Well, Bernarda, this case has been high profile, right? I mean, it's been surrounded by media coverage from the start, and it was difficult enough to find a jury in the state trial who had never heard of the case, but now the court is looking to impanel a jury after these defendants were convicted of murder, not to mention the McMichaels and their withdrawal of their guilty pleas pursuant to an agreement with federal prosecutors to a charge that they're now going to fight. Do the attorneys and judge have their work cut out for them?
Absolutely. After jury conviction, especially here in the state case, especially in a trial that was so high profile, you got to think there was gavel to gavel coverage on several networks of that trial, from the beginning jury selection all the way to the end, to the verdict, to the time of sentencing. So that complicates jury selection because it's going to be difficult to find a jury that has not, number one, heard about the case, number two, hasn't heard about the conviction, number three, who possibly hasn't heard of the plea and the plea being withdrawn. So the question would be, despite you hearing of those three things, and I really find it very difficult for someone to put aside that they heard that the McMichaels were willing to plead guilty and still judge the facts on its own without letting those other decisions play a role in their deliberation. That's why it's going to be so much harder to find a fair and impartial jury in this federal case.
Well, so far, the majority of those who've qualified to sit as potential jurors have been white. And as we know, there was a lot of concern when a majority all-white jury was impaneled in the state's case. Should there be concern that this may happen again, even though that jury did convict all three for murder?
So it's highly likely that in this case that you may end up with a jury of 12 Caucasians. And the reasons is because unlike the state case, the federal case takes into account a jury pool that encompasses a lot more counties. When we were talking about the state case, it only encompassed one county for the jury pool. But here you're talking about across the state taking a jury pool in order to select 12 plus a group of 6 alternates.
Bernarda, let's talk about evidence, because, I mean, you know, the state prosecutors stayed away from race. The issue of race never came up in their pursuit to convict these three individuals for murder. But this is unavoidable in the federal trial, right? Because this is a hate crime. So how can prosecutors demonstrate what was in these defendants' minds at the time that Ahmaud was killed?
So that's what's going to make the federal charges a lot more difficult to prove than the state charges, because the federal charges are based on the intent of these three defendants, what were in their minds when they decided to hunt, chase, and ultimately kill Ahmaud Arbery. And in terms of evidence itself, yes, we can make the arguments, we can make the inferences that they can infer based on their actions and by certain words that they use. For example, you do have Travis McMichael after he kills Ahmaud Arbery over the body and allegedly says something about you effing Ed. However, you don't get that evidence in unless you have William Roddie Bryan testifying against the McMichaels, because there's no other way you'll get it in unless you have one of the McMichaels admitting that that statement was made. So it's not going to happen. You have the Confederate flag. Let's see what the prosecution does in regards to the Confederate flag being on the license plate, as the license plate as of the McMichaels. You also have that both the McMichaels as well as William Roddie Bryan refer to Ahmaud Arbery as the black man, as the colored man. Maybe that's the normal down there and down south. So maybe a jury will look the other way when we're talking about colored man, even though I can tell you in New York City, we don't use that type of language when we're describing blacks or African Americans, when we're describing us. Aside from that, what you will get is that there is evidence as to Travis McMichael, the shooter, about social media posts in regards to how he talks about Black people, how he talks about minorities. I believe as to the father, there's a phone call from prison where he refers to his daughter talking about take down certain posts from social media. But what do you have in regards to William Roddie Bryan, that his intent was to chase down, hunt down, kidnap Ahmaud Arbery, and that it was all based on hate in terms of being racially motivated, this entire crime? So that's pretty much what you have so far, and the inferences and the arguments that you can make at closing arguments. But will it take you over the hump of beyond a reasonable doubt? We'll have to wait and see.
Well, that standard, beyond a reasonable doubt, that is on the government, right? They have to prove the elements of the charges against these three defendants, and the defense doesn't have to put up any shred of evidence if they chose not to. But with regards to how the prosecution is going to be approaching this, saying that these three were motivated by race in their target of Ahmaud, it almost makes the defense have to put up some evidence. So what do you think they're going to do in order to basically prove to the jury that it was anything but race?
Yeah, so that's going to be the difficult part. So we already know Travis McMichael testified at the state case. So technically, he doesn't have to testify. First off, like you said, neither of these three defendants have a burden. They have nothing to prove in this trial. The burden is on the prosecution. So we know Travis McMichael testified at the state trial. If the prosecution wanted, they could put in the entire testimony of Travis McMichael into the trial of this federal trial, because it's a statement that he made, and because he testified under oath, this can be submitted on the prosecution's case in chief. So I don't see Travis McMichael testifying again, because it just doesn't make sense. In terms of will you see any of the other defendants testify? If anything, I think William Roddie Bryan should testify, because he has the chance of possibly arguing that he is least culpable, and especially that when he was following the truck and Ahmaud Arbery, he can argue and say, look, it wasn't based on race. I was trying to help out a neighbor that I thought he did something, because we're not talking about citizen's arrest here. We're not talking about self-defense. We're talking about what was in the mind of these defendants when they decided to chase down Ahmaud Arbery. I will also note that despite there being a plea, this jury, that plea cannot be used as evidence against any of these three defendants at this trial.